Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Here today to talk to you about the co-defendants. So we've talked a lot about Alicia Andrews, but what about the other four co-defendants in the murder of Julio Foolio? So we're talking about Isaiah Chance, which is the baby daddy of Alicia Andrews, and then Davion Murphy, Rashad Murphy, and Sean Gathright. Those are the other four remaining co-defendants. Now we're still waiting to find out what's going to happen with Alicia Andrews as to the new trial. In the meantime, the co-defendants are teeing up for a trial that is tentatively set for April. However, they have tons of motions that are pending and were recently argued. Now, I started watching some of them. I don't know if you guys checked it out, but it was like 6 hours worth of argument and a lot of lawyer mumbo jumbo, but really serious issues because several of the co-defendants are being charged not only with the premeditated murder, but it's a capital offense and death penalty is on the table for them. And so certain motions are actually focused on the death penalty and whether or not it's constitutional or not. And the attorneys raised some issues similar to what we talked about in the Wade Wilson, like whether the 8 out of 12 is constitutional for them to impose the death penalty. So I'm not going to get into all of those details since we've already talked about that, but there are some other interesting motions that they are dealing with about suppressing evidence, about the gang activity and gang charts. Even one of the exhibits, and I may be able to show you guys, they want to keep out these charts that identify who the gang members or gang affiliates are, and the defense is trying to keep that out, and the state of course says that it's all related and it should come in. So let's listen to a few of the arguments and then we'll go through one by one. On second thought, if you hadn't seen the whole Wade Wilson issue, is Florida, for the death penalty to be imposed, the Supreme Court at one point in Florida had said that a jury has to find for death. Basically, there's two phases. There is the guilt phase. Jury has to decide guilty or not guilty. If they decide that the person is guilty, then it goes to a second phase, which is called the penalty phase. What should the penalty be? Normally, jurors are always told that the judge is the one that decides the sentence. The jury just determines the facts. So their responsibility is just guilty or not guilty. And they don't need to worry about what the sentence is going to be. Don't let that get into your thought process. And that's what they tell the average juror. However, in death penalty cases, they will have a say in what sentence gets imposed. Ultimately, the judge has the final say, but the jury has to make this recommendation. So after the guilt phase, if the defendant, so the co-defendants in this case, the ones where the death penalty is being sought, if they're found guilty, then there will be a second phase of the trial called the guilt phase. And then the jury, we're talking about 12 jurors, they have to determine should life be imposed, life without parole in Florida, or death. And in order for them to do that, they now only need 8 out of 12. So if that makes sense, basically they first have to decide, are they guilty or not? And if they do decide guilty, then there's this second mini trial that is focused only on whether or not the death penalty should be given in this situation. And at that point, stuff that would not have necessarily come into the trial gets to be shown to the jury. The state presents what's called aggravating factors, things that make this more egregious or worse, or why this is so horrible that it deserves the death penalty. And then the defense, their job at that point is no longer to argue that the person's not guilty or they're innocent. At this phase, it's saying why they deserve life instead of death. And they can present family members, and that's what some of the motions go into. It's like, what are they going to be able to show? Who's going to be able to testify? What evidence can they get into? And I know we have a little bit of a video on that where they're asking, hey, is this as bad as a serial killer or someone who does some sort of like terrorist act versus just this isolated incident, that it's not that egregious? And the state was objecting and the defense is saying, we'd like to be able to talk about that generally. And then the judge decides. Now, some of these motions, the judge is taking that under advisement. What does that mean? That means that she's going to think about it and then issue a written ruling. Other of the more simple, straightforward motions, the court is just right away ruling, granted or denied. In watching these hearings, I think one of the things that kind of stood out to me was this issue about how someone is determined to be a gang affiliate or gang associated or documented gang person, and how after 5 years of non-gang activity, then you can fall off this gang list. And it really seems a little bit arbitrary, like basically how you dress. If you dress in gang wardrobe, if you're in a video or seen in pictures on social media, Instagram, whatever, anything like that. You're seeing a picture and they would actually say, oh, I talked to such and such, and they show them a picture and they're like, hey, do you know if this person's in a gang? And they say yes, and that checks off one of the boxes. So one of the motions that the defense was raising is that this is really not enough. Florida actually has a gang statute or a law that lays out what the prerequisites are, but when you look at it, it really is some pretty vague stuff. Tattoos, clothes, jewelry. I think one of the things in this case was because they wear a necklace with a 23 on it, so that means that they're part of such and such gang. But it's I don't know. I guess it's concerning for me, or at least it's a cautionary tale for young people, because sometimes, especially with this whole Jacksonville, and they talk about what you hear about Crips and Bloods, right? The bigger, more well-known national gangs, Latin Kings, things like that. But when we're talking about neighborhoods, when you're like claiming you're set, but it's really just your neighborhood, this is where I grew up. It's not uncommon that people bond, and like, why is that necessarily gang? And maybe I just live there, and maybe I hang out with them because we went to school together. Maybe we just like these kind of clothes. Is that enough to make me a gang associate? And the reason this is important is that the punishment is higher. There's a score that gets attached on your score sheet. So you get an enhanced punishment just by nature of being associated with a gang. And it can be kind of a loose association and really based on hearsay. Anyway, so I think it's good for people to know. I don't think people really realize it. And in one of these motions is the cop took pictures of one of the Murphys. I think it was Deshaun Murphy.
You join in prison?
Oh, no. I don't know what that is. It's just a blue man.
What's KD? Roll it. You can roll it.
KD, that's my little sister. That's my little sister. You see KD Cosmetics?
Okay.
Makeup.
That's her lips.
Yeah. Lip gloss brand. She wants to start a makeup company.
187. Nice. What's 490? What's 490?
Time.
There's no 90 minute time. Money bags? Where's the free case badge tattoo at?
Free case badge?
Yeah.
I don't know, fool. I don't know who
You know him?
Who's case badge?
Oh, man. Is that like a Celtic thing?
Nah, Saint something. I just remixed it in my own way. Be different.
Okay. You said Saint?
Yeah, the Saint something. You talking about the middle of my neck,
New
right?
Orleans Saints?
Nah, yeah, New Orleans Saints.
You're a
New Orleans
Saints fan?
Yeah. I just mixed it up in my own way, try to be different. Yeah, that's my favorite player, though.
For real?
Yeah,
For real?
but
How many photographs
Roy's
did you
running
take?
back all the time.
I don't know the exact
Jacoby
amount.
Wright. Who's Jacoby Wright?
My little brother.
How many brothers you got?
No, I know that's the picture you wanted to get. No,
At that point, the photograph that you appear behind Mr. Davion Murphy, and he's got the red tank top on, you're actually pulling his tank top down, right?
No.
No? Okay.
Who you got there? You been on Ozempic?
Anyways, he's in the interrogation room and it's like, hey, let me take some pictures of you. And then all of a sudden they're taking pictures, and what are they doing? They're basically pointing out, okay, look, he's got this name and this, and look at his arms. And so the defense in that case is trying to get those pictures thrown out because they didn't have a warrant to take pictures and they didn't get proper consent. But just pictures alone, all of that, the state is going to use it to tie everyone together and to add this level of guilt just by virtue of who you're hanging out with. And so let's just listen to a few of the arguments that were raised during the hearings.
All right, good morning, everybody. States here. Defendants Rashad Murphy, Davion Murphy, Sean Gathright, and Isaiah Chance are all here. Good morning. Defense counsel's present. Are we ready to proceed?
Judge, can I address the court just briefly on what's happening today, just so I can clarify it
Sure.
in my mind? As I understand it, Judge, we are going to be arguing the motions to suppress.
Correct.
That testimony was taken last week.
Correct.
We're going to do all the capital and phase 2 motions.
Yes.
And then the balance of the motions in limine and those related to the gang history, they're going to be done in conjunction with each other on Friday.
That's my tentative plan.
Okay.
Does that work?
Yes, Judge, that would be my preference.
Okay. And, all right, very good. So, on the motions to suppress, do you all have a preferred lineup, or you just want me to pick? Anybody? Okay, all right.
Okay, so they're going to sort out because there's so many motions. Now, this hearing, last week, they actually had the detectives all come in, since a lot of them are coming from Jacksonville. And this is in Tampa, Hillsborough County. So the gang detectives from Jacksonville came over to testify, and they had all that testimony last week, but there were no arguments. This hearing is actually the lawyers now making the arguments, summarizing what came in when the detectives testified. All right, I want to start off with the first attorney is arguing for Rashad Murphy a motion to suppress his statement, an interview that he gave, and there's kind of two pieces to this, but let's take a look at this one.
If you like to find some scissors, I'll send someone that I'll get in here to get those off you, alright? So just sit down, let's come.
And for the record, you're publishing the exhibit. It looks like you're fast forwarding to a certain section, correct?
Yes, Judge, and I've already discussed it with defense counsel that there's about an hour of dead space, so we're gonna fast forward it to when the detective actually comes
Which,
in.
for the record, is at what point in time?
It's like at 1 minute, Judge, I'm sorry, 1 hour.
Just real quick, that whole hour of dead space, that means he was sitting there a whole hour, just sitting there with no one questioning him. But I think that also, I don't think that they really pointed that out, but I think that adds a little bit to how someone responds after you leave them alone for a whole hour before they come and engage you to then try to have a conversation. But here they come in and they bring him a blanket, which later also becomes part of what the attorney starts arguing, and the state tries to say, hey, we gave him a blanket, we're really nice, and he wasn't coerced, or, you know, there was nothing wrong with the police tactics in this case.
I had to get one of these and get tired. You want one? You drink these? No? You ever had one?
Yeah, I've been drinking, but I laid off the rest.
Bad for you? I hear that too. But I used to do this thing called chewing like tobacco, and it's pretty bad for you as well. So I'm happy I'm not doing that anymore.
My family drinks
Chew tobacco?
yeah.
Well, I used to rip cigs, but then I kind of started chewing. Anywho, before I can speak to you about, obviously, whatever conversations we have, I just have to do this first. If you have any questions at all about it, just let me know and I'll be happy to explain it, okay? Are you able to read?
Yes.
You are? Okay.
I got a question.
Sure.
Yeah, I know how everybody should do YouTube, but
Yeah. Well, let me tell you something. All the things you've ever watched on YouTube, right? Hear me out, because I understand your question. Listen to me. I've been doing this job for a hot minute, so I understand your question. But your question is in reference to Jacksonville videos. We have probably different record request laws than what maybe Tampa might have, right? This isn't a Jacksonville case. You feel me?
Yeah.
So the conversation we have is important, but I do understand your concern. And I can promise you that what your concern is directed to like crime circus and all that shit you see on YouTube, that's Jacksonville related. We don't have control of that in Jacksonville. Tampa's a different story. Does that make sense? Can you demonstrate you're able to read by reading that first line for me? Perfect. I'm going to read the rest, and if you have any other questions for Rashad, do people call you Rashad? Just let me know. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before you make a statement or before any questions are asked of you, and to have a lawyer with you during any questioning. If you cannot afford to hire a lawyer, one will be appointed for you before any questioning if you wish. And if you do answer questions without a lawyer present, you will still have the right to stop answering questions at any time and consult with a lawyer. Do you understand all that? Okay. Do you know how to sign your name? Okay, if you could print your first and last name on that line, and then sign your name on that line, and then once you do that, I'm going to write my information just above yours. You're fine, man. It's like creeping up on 3 in the morning. Don't blame you.
That blanket help you out any?
Yes, sir.
Oh, smokes.
Can I get some?
I mean, what? Piece of paper.
No, I just.
Oh, that's fine, buddy. I mean, if you're yeah, just, look, that's fine. I'm good with that. Just sign your name and I'll sign right above it. Mine's not a hell of a lot better anyway, so. My name is Chris. I don't know if I introduced myself when we were talking the first time, but this is my ID number. It's 78576. Some people call it badge number, but that's mine. There's a couple questions down here I'm going to just go through real quick. Sir, what's your date of birth?
Okay, so That's just a little bit there, and then they just start talking. They start talking about the case, and then you'll hear in a little bit the attorney's argument. But this was the reading of the rights, and sometimes when they read the rights, they memorize it, and you just say it. A lot of agencies now are getting a card or a sheet of paper that has all the rights. You have the right to remain silent. You have the right to an attorney. You have the right to have an attorney present with you when you are being questioned. And at any point, you could actually stop the interview and ask for an attorney. So all of that needs to be said. And then they're supposed to, at the end, say, knowing all of this, one, do you understand your rights? And then do you wish to waive those rights and have a conversation with me? Here, and you'll hear the attorney argue it, but here the issue is you don't hear him ask that. It's kind of basically like, yeah, here, I have this form. Go ahead and just sign it. And he signs it. And what you don't see here is that about a month before, we talked about Gwinnett County, Georgia, is where Rashad Murphy was stopped because the police were trying to track down the car. They had this lead that they knew the vehicle that was involved in the shooting, and they did the license plate readers and tag readers, and they were able to track the vehicle to Gwinnett County. And then they go make a traffic stop of this vehicle, and then they arrest him for maybe resisting, again, probably some sort of pretextual or minor charge to be able to arrest him, and then ultimately hopefully be able to question him. And Tampa police had already made contact with Gwinnett County. They go up to Gwinnett County, Georgia, and they meet with Rashad Murphy, and they want to talk to him. And they want to talk to him about the murder in Tampa. So there, Detective Ramos actually meets with Rashad Murphy, and he goes over and reads the rights to him, tells him what he's there for, and he asks, do you wish to speak to us? And Rashad Murphy says no, unequivocally, meaning without a hesitation, without a doubt. He said no, he doesn't want to talk to them. And then that's the end, and Detective Ramos respected that, which is what law enforcement is supposed to do. If they say no, or if they say they want to speak to an attorney, I think that's what it was. He said that he wanted to speak to an attorney, and or that he wouldn't talk, or he'd be happy to talk if he had an attorney present, something to that effect. The point is that the interview was ended, and a story. So the issue that the defense takes is, my client said no. The defense attorney is saying, my client said, and he was clear, that he invoked his right. He invoked his right to remain silent. He invoked his right to an attorney. And you guys came back knowing, and this detective that is the Jacksonville detective that's in this interview had been in contact the whole time with Detective Ramos from Tampa. And he knew exactly where stage of everything that they're at, and they really want to be able to talk to Rashad Murphy. So they're like, hey, you should go try to talk to him. And so he goes and re-engages with him. Now, Florida case law is not great on this. Basically, and I say not great, what the law on this is that law enforcement, they can, if there's a break in time, if there's a certain amount of time and the law enforcement leaves and you disengage, there are certain things that if law enforcement comes back, or sometimes there are cases where the defendant changes their mind and then they approach law enforcement. They're like, hey, okay, on second thought, I'd like to talk to you. They have to then make sure it's still a valid waiver. So there are times where you could come back together and then keep talking even though the person invoked, but they have to acknowledge or say that they now want to talk to you. This is a little bit tricky because here you hear him say, hey, we're separate from Tampa, and it goes on, and he very clearly says, we're not Tampa. We don't do things like Tampa. And it takes a lot of effort to act like you're talking to us, but you're not talking to Tampa. But obviously they're going to give all this information to Tampa, and that's what ends up happening. And so that's what the argument is with Rashad Murphy's motion to suppress. And then what I was mentioning about the pictures of the tattoos, this is Davion Murphy's attorney questioning the detective about what they did with respect to the photographing of the tattoos.
The July 30th interview was not initiated by Mr. Murphy, correct?
Correct.
And was it Detective Ramos that contacted you, or vice versa, you contacting him saying, hey, Murphy's in custody?
Yes.
That would be you to him?
Yes.
And his response was, go ahead, I would like you to interview him.
Yes.
Did you all discuss his prior invocation?
At that time, no.
And is there any reason why you attempted to interview him knowing that he had previously asked for counsel and invoked his rights as it relates to this same and particular incident?
Yes.
Why?
Because I wanted to obtain his statements that he was willing to provide in reference to this investigation.
After he had previously invoked?
Yes.
Did you talk to him about his previous invocation?
No.
And Did you consider this to be a separate interview?
Yes.
And you were aware, obviously, that the arrest in Jacksonville was an arrest for the murder in Tampa?
Yes.
Do you recall why Detective Ramos was not able to come to Jacksonville and conduct that interview on the Tampa murder?
I don't recall.
During the course of your initial interaction with Mr. Murphy, after you read him the advisements, you essentially just say, hey, if you have any questions, let me know. Is that a fair statement generally?
At the conclusion of reading his rights, I did ask him if he understood. His response was yes, and then I followed up with that with what you just said.
Okay. Do you recall whether you ever asked him whether or not he wished to waive those rights?
I think that
She doesn't think he agreed, but either way, he asked him, and then this is what's called acquiescence to authority. So we argue that sometimes people agree, but you're not really agreeing. You're in custody, you're detained, it's law enforcement, so any agreement is because I think I have no other choice. So this just goes on, and the bottom line is his attorney is trying to argue that he really didn't have a choice. At the beginning, he actually tells them he'd been to prison, and so they've taken pictures, like, you guys already have this, you don't need to do it, but they kind of insist, hey, we're going to get it from the jail anyway, and so they do it. And so one of the arguments, the defense is trying to suppress these photographs because you didn't get a warrant. He had a jacket on, so he had to remove it. And the only way law enforcement could obligate you to do that is either you agree, consent, which is what the state's arguing happened here, or they needed a warrant. And the defense is arguing it wasn't really valid consent. It was him just feeling like he had no other choice. And those are the arguments. And why does it matter? Is because the tattoos that they end up uncovering, they're trying to link that again to this idea that he's involved in a gang, that he's a member of a gang, and that way they can seek those gang enhancements related to sentencing and also as part of the conspiracy and what they're trying to lay with the elements on the different charges that they're facing.
Okay, all right, Mr. Gonzalez, you're closest to the podium. So, all right, let me just take a look here.
Motion to suppress statements, Your Honor?
Sure, we've got the motion to suppress the cell phone and the motion to suppress statements. So why don't we kick off with the motion to suppress statements? And I'm going to give each side 30 minutes total. So, okay?
Judge, as it relates to Defendant Rashad Murphy's motion to suppress statements, we are seeking to suppress statements made incident to an unlawful interrogation that took place on July 30th, 2024. If the court might remember, this began with the silver Chevy Cruze having been found in Gwinnett County. Mr. Murphy was driving the Chevy Cruze. After he fled from the Chevy Cruze, he was tased and taken into custody. And again, this was in Gwinnett County. At that particular time, as the court will remember, the Chevy Cruze was the evidentiary basis at that particular time. There had been no additional evidence that had been determined relating to Rashad Murphy. And after his being detained in that particular case and arrested for a misdemeanor in Gwinnett County, Detective Ramos and Detective Campbell traveled from Tampa to attempt to take a post-Miranda statement from Mr. Murphy. He was given Miranda advisements as testified to by Detective Ramos, and essentially he testified that there was no evidence at that particular time. They were in possession of no evidence at that particular time linking Mr. Murphy to the homicide. This was simply an alert on the car based on surveillance footage that had been obtained, as well as license plate reader information. During the course of that initial statement on June 26 of 2024, Mr. Murphy clearly and on multiple occasions invoked and requested to have a lawyer, went so far as to say, hey, look, when I get a lawyer later on, I'll reach out to you guys. But at that particular time, Detective Ramos ceased his questioning, and he and Detective Campbell left Jacksonville. It's important to note that during the course of the gathering of this evidence, Detective Drabick had assumed the role in Jacksonville of keeping in contact with Detective Ramos on a regular, I think they almost called it a live basis, update.
All right, this is going to go on because then the attorneys are just fleshing out basically what I said. He's going to talk about how Drabick is he's the detective out of Jacksonville, and that him and Detective Ramos have stayed in contact, and that's why it was wrong for them to come, even though it was a month later. And then the state is going to come back and argue, hey, there's this case where it says police, after waiting 14 days, if they go back and talk to the person and that person waives their right to speak to the police, it's fair game. It doesn't matter that they had invoked or they had said that they wanted a lawyer before. And here it was 30 days apart. So the state's argument is there was nothing wrong, and he obviously understood his rights because he knew how to say no the first time. So the second time when they read him his rights, it really didn't matter. And ultimately, I don't know what the judge is going to decide. She said that she would issue a written order on this motion, and then you heard him talk a little bit about the car. All they knew was the car. Like, just because you know that the video from where the shooting happened, you can't tell who's in the vehicle. So how do they know who was actually in the vehicle? And then when they do arrest him, then there's a question about whether or not they can use the cell phones that they found in there. And all of the motions, there's a lot of these motions, the attorneys are able to adopt the other attorney's motions. So you'll hear them say, we're adopting their motion, meaning we're arguing the same thing for our client on some of them that are the same grounds or same basis. The other thing that I thought was funny, I saw that one of the attorneys, I think it was Rashad Murphy, he filed his own motion. So a lot of times this will happen, people when they're in jail, someone that's in there with them, the jailhouse lawyer, they'll tell them, hey, you should file a motion like this, and they'll do a pro se motion. Pro se means on your own without an attorney, but he has an attorney. So if you ever send a letter from the jail as an inmate and you send it to the court, one, everybody gets it, and two, they're not going to take it. It gets stricken because you already have a lawyer, so you don't get to file your own motions. You have to go through your attorney or get rid of your attorney. So he filed a pro se handwritten motion from the jail, and of course it was stricken. Anyway, there are more hearings coming up at the end of this week, and then the judge is going to decide as far as suppressing the evidence about the cell phone data that they got, about these interrogations, about whether or not the gang activity or the charts are going to come in. Are they really experts? The state is trying to call these guys experts on gangs. Like, what makes them a gang expert? So there's a lot of information in there, and we'll keep touching base as things unfold. But either way, the other thing that's pending is whether or not they filed a motion to separate the co-defendants. And they're saying, hey, if evidence comes in against Isaiah Chance, it's going to be prejudicial against Davion Murphy, for example. And they're saying that my client should be separated from this bunch. And the state's argument on that motion is these are all inextricably intertwined, meaning it's all relevant. They're all working together, and the jury can sort it out. So there was a hearing on that as well, that it's not too complicated for the jury to be able to watch and say, okay, yeah, this guy participated in this, or we're not going to hold this against this defendant because it doesn't pertain to him, and we don't need to have 4 different trials on these facts, that it's really not that complicated. And that motion is still pending for the judge to decide. Is it going to be severed? Is it going to be separate trials, or will they be tried together? Is the evidence for the phones and the statements and the gang activity, is that coming in or not? And then eventually it's going to get teed up for trial. And we'll keep you guys posted. Thanks as always for watching, and we'll be back soon. Take care.